2005, credit card companies, commercial banks, and other businesses lobbied Congress to pass a new bankruptcy act that would reduce the ability of some debtors to relieve themselves of unwanted debt through bankruptcy. In response, Congress enacted the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. So up until that point, there were a ton of people that were doing that. They were filing for bankruptcy, not because they necessarily needed it, but just because, whatever. And when we talk about that, let's talk about how that affects everybody. So you have the person that's filing for bankruptcy, you're taking all of their debts and you're putting all of their debts back onto the person that gave them to them. So all of these credit card companies and mortgages and mortgage lenders and all other kinds of credit situations, basically that debt was coming back to them and being erased from that individual person. So they had no recourse to do anything and go after that person at all. And so they were stuck with that debt. So if you think about that, do you think it's important for businesses to be cautious about who they lend to?
Yes, and also have insurance.
Yes, and absolutely have some insurance for sure. So the 2005 Act substantially amended federal bankruptcy law, making it much more difficult for debtors to escape unwanted debt through bankruptcy. Federal bankruptcy law, as amended, is called the Bankruptcy Code, which is contained in Title 11 of the U.S. Code. The Bankruptcy Code establishes procedures for filing bankruptcy, resolving creditors' claims, and protecting debtors' rights. The changes made by the 2005 Act are integrated in this chapter, so we're going to discuss that a little more. So then in 2009, or in 2007, when the recession hit and continued for that little bit of time, the housing prices dropped considerably and often to below the amount of the loan on the house, like I talked about before. So in addition, many persons became unemployed. It was really kind of crazy. I don't know how much it affected you guys, but it was quite I was living in Las Vegas at the time, and it really affected our city in Las Vegas for sure. So
I worked in the car business, and it was crazy.
Yeah,
it was nuts.
It's really sad. It was a really sad time for us. So in addition, many persons became unemployed. We talked about that. So often families had their homes foreclosed on, while many other homeowners were faced with the possibility of foreclosure. And in response, Congress enacted the Helping Families Save Their Home Act of 2009. So this federal act amends credit and bankruptcy law, and the act's goal is to help struggling borrowers keep their homes. Major provisions of the act and rules adopted are that number one, qualifying for Chapter 13. So the act expands the debtor's eligibility to file for Chapter 13 bankruptcy by excluding home mortgage debt under certain circumstances from the current debt limitations to qualify for Chapter 13 bankruptcy. The existing law provides that if a debtor's total mortgage debt is more than $1,149,525, the debtor is not eligible for a Chapter 13. The new law changes this by excluding debts on the debtor's principal residence if either the current value of the home is less than the secured debt, or the debtor's home was sold in a foreclosure or surrendered and the value of the home is less than the secured debt limit. Number two, they require credit counseling. So the new law eliminates the need for pre-petition credit counseling, and therefore a debtor may file for bankruptcy if the debtor submits a letter that he or she has received a notice that the foreclosure may commence. And this allows emergency bankruptcy filings. And we'll talk more a little more about that credit counseling thing in a minute. Number 3 is active bankruptcy cases. The law permits debtors to seek mortgage modifications while in an active bankruptcy case. This rule will prevent mortgagors from saying no to mortgage modifications during a bankruptcy case. The result may be that the homeowner can obtain mortgage modification that lowers mortgage payments while filing for and completing a Chapter 13 bankruptcy. So basically, they made that ruling so that these debtors could actually hold on to their house. Going through bankruptcy, they'd still be able to hold on to their house and not foreclose on it. And it was a good situation for both the banks and the homeowners because it helped so that the banks weren't foreclosing on as many properties, and the bankruptcy was able to help those homeowners get to a spot where they could actually pay for those mortgages. Mortgage lenders. So number 4 is mortgage lenders, and that prohibits mortgage lenders from filing a claim in bankruptcy case, in a bankruptcy case if the lender has failed to comply with any requirement under the Federal Truth in Lending Act or the TILA. So there are procedures that have to be followed when filing for bankruptcy. First, the debtor must attend, and we talked about this a little bit, the pre-petition and post-petition counseling. So that second ruling of credit counseling, it eliminated the need for the pre-petition counseling, which could take, I think it was 180 days or something like that for that. So it made it so that you could get to that bankruptcy process faster. The counseling is meant to provide the debtor with information on responsible financial practices. So they're not just going to allow you to erase your debt and not learn from this mistake or learn from this situation and move on with a greater knowledge of how to manage your finances going forward. Second, a petition is filed with the bankruptcy court. An attorney must certify the accuracy of the information in a bankruptcy petition. So in those situations, an attorney would have to be retained in order to at least review the information that was being submitted with the petition, if not retained for the entire bankruptcy proceeding. Next, an order for relief is filed, and then a meeting of the creditors is held where the debtor in question is questioned under oath with creditors present. The creditors must file a proof of claim against the debtor if for any claims that they have. So if they fail to provide that proof of claim, then their amount that has been that the lender or that the borrower owes them will not be considered in the bankruptcy proceeding. So that's bad for them. So they receive a notice, and I can tell you I received several of those when I was working as an appraiser. We had a lot of things going on, and so I received a ton of those from people that had gotten appraisals with us. And it basically said, these people are going into bankruptcy. If they owe you any money, please submit it within this specific amount of time. And if you don't submit, or if you don't want to attend the meeting of the creditors, then you will not be recognized as someone that they owe. So at that point, your debt is worthless. It means nothing because you haven't pursued it and tried to make sure that you could get that debt, get that money back. A trustee is appointed to the case. An automatic stay is issued. So basically what an automatic stay does is it tells all the creditors that they can no longer harass you for money. So they can't call you and ask you to pay. They can't do, they can't request that you pay anything. They can't send you any kind of statements in the mail, nothing. None of that can happen anymore. After the requirements of the bankruptcy has been met, a discharge of debts is issued by the court. So like I said, with a Chapter 7, that happens fairly quickly because there's no payments or anything that have to be made. It's all like a lump sum thing and it's taken care of and it's done. With a Chapter 13, there's a little more to that, and we'll talk a little more about that in a minute. So after the bankruptcy is discharged, a debtor can enter into a reaffirmation agreement with a creditor if they want. So after they're done, basically the reaffirmation would make it so that the debtor now owes the creditor. So why do you think that they would do that? Why do you think that anyone would say, yeah, I do want to reaffirm my debt with you?
Maybe if they can keep their asset, if they do it like their car, or their house, or something big.
There you go. Yeah. So, and we talked about the mortgage modifications. So that's basically a reaffirmation, but it was modified. The terms were modified. So let's say that you go through the bankruptcy proceeding and then a creditor reaches out to you and they say, hey, we know you just went through bankruptcy. We had a debt with you. And if you pay us, let's just say it's a credit card. If you say that you will reaffirm this debt for this amount, and it's usually, or it can be a cut down amount, like it's modified. It's a modified situation in most cases. Then if you cut down this amount, then we will continue to let you use our credit card. So that might be a situation. The car, like you said, a vehicle that someone might have a vehicle, they want to keep the vehicle. They say, okay, you can keep the vehicle, but you still have to pay us this amount of money. So, you know, it can be reaffirmed after the discharge is done.
I have a quick question.
Okay.
With lending, because I know in the car business, if you have a Chapter 7, they really, I mean, banks really won't look at you as far as giving you a loan. Is the same thing true with like housing loans as well? Or are they lenient?
It depends on the lender, but yes, absolutely. What will happen is when you go through a bankruptcy situation as an individual, you will be looked at differently when it affects your credit. So everybody has that credit score. Your credit score will tank. You know, everything will get a lot harder to finance anything. They don't want to touch you because you have had a bankruptcy. And it takes a period of time, I think 7 years for it to go off of your record, off of your credit record. So you have a lot of time that you are going to struggle to get any new credit after a bankruptcy.
Yeah, we experienced that a lot after the 2006-7 deal.
Mm-hmm.
That was bad. Sorry.
Yeah, it was really crazy, and a lot of people had a lot of issues. So yeah, and so you know, you couldn't really do much with the those people couldn't really do much with financing anything new. There were a lot of people in our area that actually went and bought another house before they could actually, or not bought, but they went and rented another house. So they got on a lease agreement before the banks foreclosed on their home, because they knew that if they waited until after, they wouldn't be approved for that lease.
So true. Wow. A lot of people do that with purchasing of a car too. Like depending upon where you're at in your bankruptcy, you can't, like everything is frozen and it's already submitted. But yeah, there's a lot of people, they try to, you know, consolidate and condense and keep what they have or trade it in or whatever.
Yeah, absolutely. Yeah, so it's kind of crazy. And So in a chapter 13, the debts and the income are evaluated and a plan is made up to pay, and that one is structured up. So if I were filing for a chapter 13 and I had $10,000 per year in income and 40,000 in debt, I may be required to pay $5,000 for the next 5 years. And then the remaining 15,000 would be written off at the end. Why would it only be $5,000? Again, it's back to the same thing as like a garnishing your wages. You still have to live. So they still have to give you something to be able to live. And that would be written into the plan. So when you do the plan, you would have to say, okay, here's all my debt, here's all my income, and here's what I need to live. And then all that would be considered, and then a payment plan would be structured. And then at that point, you would start your process. So now we were just talking about how it takes, and I think it's 7 years to go off your credit after you have a bankruptcy, Chapter 7 bankruptcy. In a Chapter 13, it's 7 years to go off your credit, but it also takes a period of time. And I don't know if it's always 5 years. I'm not sure exactly. I found a 5 years, and I think that was just one of the numbers I came up with. But depending on how long you have to pay, it's that length of time, and then an additional 7 years on top of that. So you're in that bankruptcy state to where you can't receive credit for a longer period of time for a Chapter 13. So it takes a lot longer to adjust after that. There are certain debts that can't be discharged in bankruptcy. They are listed in here on page 453. It's exhibit 453 in my book. It's exhibit 24.1, debts that cannot be discharged in a bankruptcy. So things that can't be discharged would be like claims for income or gross receipts taxes that are owed to federal, state, or local governments that are accrued within 3 years prior to the filing of the petition for bankruptcy. 421, thank you. Certain fines, penalties payable to the federal, state government units, claims based on the debtor's liability for causing willful or malicious injury to a person or property, claims arising from fraud, larceny, embezzlement by the debtor while acting in a fiduciary capacity, domestic support obligations such as alimony, maintenance, child support payments, unscheduled claims, claims based on consumer debtors' purchase of luxury goods or services for more than $650,000 or $650 from a single creditor on or within 90 days of the order for relief. Cash advances in excess of $925 obtained by the consumer debtor by use of revolving credit line or credit cards used with or on or within 70 days of the order for relief, judgments and consent decrees against the debtor for liability incurred as a result of operation of a motor vehicle, a vessel, or aircraft while legally intoxicated, a debt that would result in the benefit to a debtor that outweighs the detrimental consequences to a spouse, former spouse, child, or debtor, and an amount owed to a pension, profit sharing, or stock plan, bonus plan, and loans owed to employee retirement. So what it's protecting here is it's looking at you and saying, if you have committed a crime, you still have to pay for that crime. If you have debts with the federal government, you still have to pay for those debts. If you have debts to your retirement, which is your money, you still have to pay your money back. If you have debts that are, if you go out and spend a ton of money and then walk in and say, I want to claim bankruptcy, they're going to go, no, that's not going to work, right? So those are basically the debts that I just explained or just listed in here are ones that are that the reasons are because of it was either a federal debt, it was something that was done illegally and you've got to pay for the consequences. It's money that you owe yourself, or you owe for child support or alimony or those types of situations that those cannot be erased or discharged. There's also certain things that cannot be taken from you. You still have the right to live. So there are certain things that could not be taken from you. That's called exempt property. And that stuff would be things that you would be able to keep in a bankruptcy. Chapter 11 bankruptcy is debt or reorganization, and this is only used for businesses. It works a lot like a chapter 13. They look at all the assets of the company, all the liabilities of the company, and they say, okay, what can we do? And then a plan is made to reduce the debt and so that the company can operate again. Let's take a look at, it says, it's a block that says business environment, and it's a General Motors bankruptcy, and it's on page 465 in my book. It's almost the end of the chapter. 425, thank you. So if you guys could just read through this really quick, and then I'll just read through it. Let me just get a drink of water real quick. Okay.
What is that thing
Sorry,
called?
that was the wrong page.
Oh, wrong page.
What am I looking for?
So it's a block that says business environment, and then it says General Motors bankruptcy. And I don't know, some of you guys may have heard of this General Motors bankruptcy that happened, because it was a pretty big deal.
Page 433.
433, thank you.
What page is
And
it?
465 in my book.
Okay.
So for those of you that have the same book as I do.
Yeah, I flipped right to page 425. I was like, whoa.
Okay. So General Motors, or GM, originally started in 1908 and grew to be the world's largest corporation. In 1950s, 1960s, 1970s, and 80s, they were profitable times for GM as it expanded operations in the United States and worldwide. However, beginning in the 70s, foreign competition began to make inroads into the U.S. Automobile market. And by the end of the first decade of the 21st century, GM was losing billions of dollars every year. This led GM to consider a once inconceivable solution to declare bankruptcy. Luckily for GM, the US federal government decided that GM was too big to fail. The federal government provided GM with a bailout of taxpayers' money, provided GM with a bailout of taxpayers' money. In 2009, GM filed Chapter 11 bankruptcy and reorganized its financial structure and operations. At the time of the bankruptcy filing, GM had liabilities of $172 billion and assets of $82 billion. Okay, so for those that took my accounting class, you know, assets and liabilities are two things in the accounting equation. And with capital, they have to equal, right? So 172 billion to 82 billion, there's a large gap in that. And for everyone else, the assets are what they own and the liabilities are what they owe. So, so they owed 172 billion and they only had 82 billion in assets that they need, those things they need to run the business, right? So the GM bankruptcy was one of the largest bankruptcies in US history. The results of GM's bankruptcy were that the US government provided more than $50 billion of taxpayer bailout money to GM. In exchange for the bailout, the federal government, AKA the US taxpayers, received 60% of the new GM stock. The Canadian federal and provincial governments, which provided more than $8 billion of bailout money, received 12% of the GM stock. The United Auto Workers, a labor union that represents the majority of GM's non-management workforce, agreed to concessions of lower wages and benefits in exchange for 17.5% ownership in GM. GM bondholders who held more than 27 billion of GM's bonds were converted from bondholders to stockholders and given stock worth only the fraction of their original investment. GM shed more than 2/3 of its debt, reducing its pre-bankruptcy debt of 54 billion to only 17 billion. In exchange, the unsecured creditors were given 10% ownership of GM. GM's shareholders at the time of bankruptcy had their value of their investments wiped out. GM closed dozens of manufacturing and assembly plants and other operations in the United States. GM shed more than 20,000 blue-collar jobs through buyouts, early retirement offers, and layoffs. After the bankruptcy, GM employed approximately 40,000 hourly workers in the United States. GM canceled more than 2,000 of its 6,000 dealership licenses. GM eliminated its Pontiac, Saturn, Hummer, and Saab brand names. GM pared down to 4 brand names vehicles, which are Chevy, Cadillac, Buick, and GMC. In addition to the bailout money, GM also received 15 billion of tax benefits from the federal government. Subsequently, GM has issued stock in a public offering, and the federal government has sold back much of its stock to GM for about half of what it paid. In total, including unpaid bailout money, and tax benefits given to GM, the American taxpayer will end up losing approximately $35 billion on the GM bailout. The GM bailout has proven the adage, what was good for the country was good for General Motors, and vice versa. General Motors Corporation, Chapter 11 case number blah 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 blah. That's where the bankruptcy went through. So they've got a bankruptcy case number here that if you wanted to look up, you could see that. What is the public policy that allows companies to file for a Chapter 11 reorganization bankruptcy? Are any parties hurt by Chapter 11 bankruptcy? And should the federal government follow the axiom that some companies are too big to fail? So we're not going to get into this too much, but let's talk about the parties that are hurt here. You heard all those people that had to, all the workers that had to take pay cuts, all the governments that were contributing for stock that basically meant nothing. They sold it back for half the share amount or whatever. They did tax credits. They did all these things and erased a lot of their debt or reorganized a lot of their debt so that they now went from, what was it? It was from 54 billion to 17 billion. So that's a lot of money. But what would have happened, do you think, if the government would have let GM go out of business? Who do you think that would have affected?
Population.
Their
people.
workers.
The workers, the population, anyone that has ever bought a GM car, a vehicle, because now there's no more warranty stuff. There's no more parts. There's no more any of that. All these dealerships that sell those vehicles are closed, you know, all those things. It's just a very big waterfall of you know, effect. It just affects and affects and affects all down this waterfall. So the government looked at everything and they said, look, if we were to do this, the people that it would harm in the future would be way bigger than the people that it's going to harm right now to take care of this situation. So that's where they came up with that too big to fail thing. So GM was too big to fail. we needed GM. GM had to be here for these types of reasons, for the reason that if they failed, being one of the largest car vehicle manufacturers in the country, if they failed, also that opens up the opportunity for other dealers to raise prices, and they don't have that competition anymore. So it can really affect and affect, and it can just go downhill from there. Excuse me. All right. So let's talk about what's going to happen next week. I am going to bring up the syllabus.
Hey, Cindy, when I was reading through chapter 4, I didn't see too much on the chapter 12 method of bankruptcy. Was that just like a part of the chapter 13 section, or was that
Yeah, so basically, and there's a little bit about chapter 12 on the very last page in your chapter. It talks a little bit about chapter 12 bankruptcy, but chapter 12 is essentially the same structure and the same information as a chapter 13, but it's specifically for fishermen and farmers. And they have, the reason that they're separated is because they have a different debt expectation to qualify. So for each of these bankruptcy types, a company or a individual has to actually qualify. So you can only have a specific amount of income or a specific amount of debt or whatever it might be. And in the case of the fishermen and farmers, a farmer cannot have debt that exceeds $4 million and some change. And a fisherman cannot have debt that exceeds 1 million and some change, almost 2 million actually. So, so that's the reason that it's separated, is because they have different levels than the chapter 13. And I don't even think that it told, I don't remember seeing that it told the amount that you would have to qualify for a chapter 13. Did anybody see that in the reading?
No.
Yeah, I don't think that it actually told you. So in the case, if ever you were in a situation where you needed to go into a bankruptcy, you would go see an attorney, and they would determine if you were able to qualify for whatever, chapter 7 and chapter 13 or any of that. So, okay, I am going to pull this up. I'm so sorry, boys. Okay.